the Constitution, Article 1, we're going to finish that today. So we still have sections 9 and 10 to go through. So we've gone through the first 8. So last week we finished off Section 8, which was the powers of Congress. And one of the things to remember about that is the very last clause in Section 8, which is Clause 18, which is a necessary and proper clause. That's the clause that allows Congress to pass laws as long as they're necessary and proper to the foregoing 17 clauses that lays out what their specific powers are. So Congress definitely uses that, a lot, because you can't possibly list all the powers Congress has in the Constitution. So they definitely rely on that 18th clause, the necessary and proper clause. So Section 9 and Section 10 are a little bit different than what you'll see in the Constitution, because these are 2 sections where powers are denied to Congress and to the states. Section 9 is powers denied to Congress. Section 10 is about powers denied to the states. So, most of the Constitution, it lays out what the powers are. But these 2 sections contain things that it doesn't give power, actually kind of takes it away, in some cases from the states especially. So let's get into that. Section 9 is about powers denied to Congress. So some of these are really applicable today due to changes in our society, but we'll still cover them all, even though, again, some of them don't really apply. But they did back then, and there's a reason why they put them in the Constitution. So Clause 1 is about the question of slavery. So as I mentioned in a previous show, this is one of the areas where slavery, although you don't see the word slavery or slaves in here, but this is one of the sections where it does cover the question of slavery, as it's titled. So this is one of the few areas that slavery shows up in the Constitution. So I'm just going to read what it says. So Clause 1 says, the migration or importation of such persons, and when they say persons, they're talking about slaves here. As any of the states now existing shall think proper to admit, shall not be prohibited by Congress prior to 1808, but a tax or duty may be imposed on such importation not to exceed $10 for each person. So that's what that clause says. So a few things about that. Notice here that they're talking about the importation of slaves. They are not talking about the slaves that are already here. Okay? So what this clause says is that basically it is giving the slave trade 20 more years to do what it can as far as importing slaves from foreign countries until Congress can step in 1808, which Congress did step in 1808. I'll get to that here in a second. But so this part of it is only talking about importing slaves from foreign countries. So this does not cover slaves that are already in the United States. And it also says that you can put a $10 tax, up to a $10 tax on each slave that you are importing. So this is one way for the government to get some money. This is almost like a tariff, if you will, on slaves. Again, not something we really want to condone today, but just remember the situation back then when they drafted the Constitution. So, so Congress couldn't do anything for 20 years, basically, after the Constitution was written. So, when 1808 rolled around, Congress did ban further importation of slaves from foreign countries. So they did do that, but again, that did not cover the slaves that are already here. That actually wasn't dealt with until the Civil War. They tried all kinds of different things between passing the Constitution and the Civil War, but ultimately they didn't work. And part of it is because this was part of the deal that was made with the southern states so that they would sign off on the Constitution. This is one of the compromises that was made. Clause 2 is about the writ of habeas corpus. So it says that habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So what this is that the writ of habeas corpus is something where if you are in jail or prison and you don't think there is a reason for you to be there, like the government has you in there illegally for some reason, you can petition, typically a federal court judge, by a writ of habeas corpus, where you ask for a hearing in front of the federal judge who looks over why you are in jail or prison and decides if you should stay there or not. Now, most of the time the federal judges keep you in jail or prison. But occasionally there are times where these judges are like, I'm not sure why the government has you in jail, so they let you out. Now, that doesn't mean your charges go away if you're there for charges or something like that, but this is what a writ of habeas corpus does. It allows you to get out of jail, essentially, if a judge thinks the government is not holding you lawfully. Now, the big exception to that, notice that it says there, unless there's in cases of rebellion or invasion, and the public safety requires it. So, Abraham Lincoln did this during the Civil War. Now, he got into a little bit of trouble here because there was a question of, well, is Congress the one who is supposed to get rid of the writ of habeas corpus, or is it the president? Because notice that when I read this, it didn't say anything. Now, lots of legal scholars say, well, it's Congress, because, this is the section involving Congress. But Lincoln did it anyway without Congress. And the Supreme Court kind of came down on him a little bit, but by that point, it was too late anyway, really, because the war was pretty much over by then. But this is, this was added because the British government was doing this sort of stuff, just throwing people in prison before the war, for no good reason, and not letting them out. So we added this to our Constitution. Clause number 3 says Congress can't pass a bill of attainder or an ex post facto law. Okay, a bill of attainder is a law that inflicts punishment without a trial. So this is one where, you don't get a trial, but you get to go to jail if the bill of attainder says so. An ex post facto law is one that inflicts punishment for an act that was not illegal when it was committed. So here again, this is a reaction to what England was doing prior to and during the Revolutionary War to the colonists. So clause 3 here says, Congress can't do this. So this is one reason why if you, follow bills through Congress or through the state legislatures, they often, nearly all of them nowadays, have part of the bill is that this bill is effective and at some future date. They put in a future date. Okay, they do that in part to satisfy this part of the Constitution. You can't have it go back, but you can have it go forward. So this involves both criminal laws and some civil laws even. So Clause 4 is another one that deals kind of with slavery, although it's not mentioned again in there. It's about direct taxes. It says that no capitation meaning it is a tax on a person, a.k.a. a tax on a slave, or any other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. So basically what this clause talks about is you can't have a direct tax on slaves anymore. And this last part about unless it's in proportion to the census or enumeration herein, that specific part has actually been changed by the 16th Amendment. So that part is no longer in play here. So a direct tax is a tax paid directly to the government. That's what they're talking about with direct taxes. So a common one that we have here is you pay your property taxes, directly to the government, right? You pay your Social Security taxes and things. That's like a direct tax. So what this clause was intended to prevent was not letting Congress tax slaves on a per-person basis, right, so that they could try and tax slavery out of existence. So this is another one of those compromises that was made. So Congress could not do a per-person tax or a per slave tax to try and tax it out of existence. So that's Clause 4. Clause 5 says that no tax or duty shall be laid on articles exported from any state. So basically what that means is Congress cannot impose taxes sold from one state to another state or from one state to a foreign country. Now, states can impose taxes, and they often do. So, that's one reason why we have sales tax. They go to the states. Right? There's not a national sales tax passed by Congress because Clause 5 won't let them do it. States can do it, though, and they do. But Congress can put a tax on goods imported from foreign countries. And that essentially is what a tariff is. So if we buy, if some company in the United States buys goods from China and China ships it to the border to come into the U.S., then, the importing company has to pay a tariff on it, assuming there's one on that good. So Congress is able to do a tariff. And that's one of the ways in the early years here that Congress got revenue for the federal government was by doing this. So Clause 6 is about interstate commerce, which is commerce between the states. So this one doesn't really come into play much anymore, but Congress can't give a preference to certain ports in the United States in terms of taxing it or by regulating the commerce somehow. Congress can't give one state's port a legal advantage over another state ports. So this was something England was doing, and this was something that was going on after the war when, again, each state had their own economy. So there were certainly some preferential treatment going on, and Clause 6 took care of that. Clause 7 is about Treasury withdrawals. So this is the clause that says Congress is responsible for spending the money. Right? So it says federal funds can be spent only as authorized by Congress. And then they have to make reports to this and publish it from time to time. So this was intended to be a check on presidential power, not letting the president actually be the ones spending the money and deciding who gets the money. This is for Congress to do. So Congress passes budget bills or separate appropriation bills that says this is how much money can go to, a certain place. Now, the president does have some say in this when it comes to federal agencies, as I'll talk about in a future show, or sometimes when there's a national emergency. So Trump, as the commander-in-chief of the military, you also have some power there, the president does, when it comes to the military money. So this is how Trump used some of that military money to build his wall, or at least, as far as he got. And the Supreme Court allowed it because of the national emergency part here under Clause 7. So the last one here is in Section 9 is Clause 8, which says no titles of nobility may be granted by the United States, and no person in federal office shall, without the consent of Congress, accept any money or titles from any foreign state. So this basically means that in the United States there's going to be no kings, there's going to be no queens, no dukes, no duchesses, that type of thing. Plus, the last part was that hopefully they would discourage bribery of federal officials by foreign governments. Now, that part hasn't worked out too well, in part because of the Supreme Court decision that legalized, bribery of politicians. So, this was something that was argued a lot with Trump. The Trump family made millions of dollars from foreign governments, and they still are. And, there's an argument that this violates Clause 8, but, that nothing was really done with that. All right, so that's the end of Section 9. So now Section 10 is about powers denied to the states. So there's 3 clauses here, so this is one of a little bit shorter here. Clause 1 says that states cannot enter into treaties or alliances. They also can't coin money. This was a problem when each state had their own economy and their own money. They can't authorize private ship owners to seize property of foreign countries. And even states cannot pass bill of attainders or ex post facto laws, as we mentioned earlier, for the federal government. And they can't grant titles of nobility, just like the feds can't. And finally, this last one was kind of thrown in there. The states can't impair obligations of contracts. So they threw that in there to protect creditors. So they didn't want the states to change contracts that were made by the federal government or even some state governments. So this was a way to protect the creditors. Clause 2 then says that no state shall, without the consent of Congress, tax imports or exports, except for financing their inspection laws. So the states basically cannot tax imports or exports from the United States. So again, this was a problem when each state had their own, 13. We had 13 different economies back then. They were taxing each other's imports and exports, and it, was ruining the economy. So Clause 2 takes away that power from the states. And then finally, Clause 3 states that no state shall, without the consent of Congress, tax foreign ships, according to what its cargo is. The states cannot keep troops or warships in times of peace. They can't make compacts with other states or foreign countries unless Congress agrees. And then the last part here is that Congress can't engage in war unless Congress consents to it. All right, so this is the end of Section 10 now. So now we've gotten through, finally, Article 1 of the Constitution. So next week I'm going to start with Article 2.